we are here now, and I want to hear from the people about their compliance with the court's order. I did provide a copy of that written memorialization of the court's order to the people at the bench prior to calling the case, just so we were clear exactly what the court was addressing. And in regards to the compliance, I'd like to hear from you.
Your Honor, I will be responding for the people.
Thank you, Ms. Pilsen.
One of the things that we did in an effort to help get everybody on the same page was put together a spreadsheet listing all of the devices in our possession. Would the court like a copy of that to follow along as we go through those today?
Sure.
Okay. I would ordinarily ask to approach. I'm not sure how to do that.
Why don't you hand it to the
Here.
deputy,
Thank you.
who just passed me,
Okay.
or just reach over?
Yeah. Dive into the.
All right, and I will indicate also, for purposes of the record, at yesterday's hearing, I was provided with a declaration from Richard Green, and today I've been provided with a declaration of Rachel Aragon and Richard Green regarding the specific evidence that is in the people's possession and the defense access thereto.
So, Your Honor, I'm going to start by identifying some categories of items that are at issue. So, generally speaking, the defense has either been given access to or a copy is currently being made of most of the items that we have in our possession that are also listed on this spreadsheet. When I say currently, I mean it takes some time for the device that writes onto the hard drive that defense provided to actually complete the writing. So that's in process. Our expert can provide, who's here I should have mentioned, Stephen Stover, can provide additional information to the court about that. We've provided that information to defense counsel already. We can provide if either the court or counsel would like the percentage of completion of that device at this time, but it's in the process of writing. That said, there are several categories of devices that don't fall into the category of defense has had access or is in the process of getting a copy of those devices. I'd like to go through those, and I can make a suggestion of how the people would recommend it be handled, and we can hopefully work through it.
Okay, just one moment. Before you commence, humor me for a moment.
Sure.
I'm not sure why we're dealing with categories, because the order didn't delineate categories. The normal procedure from the government investigation is access is access. If that means you're going to the tow yard to look at a vehicle, or the crime lab to look at DNA notes. Access is access. So I'm not quite clear why there is the necessity to categorize.
I'm glad to explain that further, Your Honor. There is a category, a group of items that the people cannot get into. And there's a group of items that the people cannot get into and also cannot make a copy of for the defense, simply because the technology available to any forensic expert does not allow that particular device to be imaged due to the type of software that the device was running.
Okay, so let me just, again, humor me.
Sure, absolutely.
I'm not a giga mega person.
Understood.
So on the second group, you don't have access to that either, and you're saying it has an additional prophylactic software issue regarding access as well.
On both of those categories, we don't have access.
Okay.
On one of the categories, we also can't make a copy.
Okay.
On the other, we could, but we would be providing something not knowing what's in it, and I would like to elaborate further as to that issue.
All right, it may not be necessary.
Okay.
Okay, so on the second, you can't make a copy.
That's
What
correct.
are the other groups?
The other group is 3 items that were provided consensually by Jane Doe 4 that have a broad range of personal identifying information on them. As the court can imagine what your computer or your cell phone would have as far as banking and name and address and family members and personal photos.
And when was that provided to the people?
Do you know the answer to that?
Because I have the appearance beginning back in June.
The appearances beginning back in June?
The case.
Yes, the case was filed in the first week of June, Your Honor. Those devices were not in our possession at the time the case was filed. I can certainly get the court the exact date that those were provided. I would just need to look through our reports and make sure that I'm providing accurate information.
So your position with that is you haven't had the opportunity to redact the evidence that's in your possession?
To redact it or to identify, or in the alternative, to identify what is relevant and discoverable and to discover that. We could go either way. My understanding from my expert is that if we redact, there will be several like full page redactions. For example, like a page of someone's checkbook would be a full page redaction. So we could still provide it redacted, but yes,
Okay.
that is in short the issue there. And then the and then the other category of devices, which I think we've resolved adequately, but I'll just make the court aware, are, well, there's two further. There's devices that have content that we've identified as child pornography. What we've done with those is we've provided defense with a PDF file of the metadata in the everything but the photos and videos. And then we've made the photos and videos available to them to review, which they've been doing since Monday.
Okay.
There's also a group of devices that have what our experts refer to as age-difficult images, where there is breast development, but the girls look quite young. So we are not, at this juncture, in a position to say with absolute certainty these are 18 or 19-year-olds rather than 15, 16, or 17-year-olds.
Are you putting those items or images in the category of child pornography?
No, those are separate because child pornography means we've identified them with certainty as being under 18. Age difficult means we have not been able to confirm their identities yet.
Okay.
But we have some concern based on the nature of the case and the other devices where we have confirmed it that they may be minors. So without further due diligence, we didn't want to simply copy the images and provide them. Rather, those also, we've handled those the same way as the child
So
pornography.
the metadata has been provided and the images are available?
Correct.
Okay. Is there any other category?
That is it, Your Honor.
The groups of evidence that you have not been able to access, let's go on the first one that you can't access. It's just blanket. Have you determined the origin and what is your position regarding the contents? And that, is this a basis for the complaint or anything else?
We know the origin of each device because they were seized pursuant to a search warrant. As far as the content, there are devices we can access that, based on witness statements, we believe do contain child pornography. They are not the basis of any of the current charges.
All right, and these items seized by search warrant, were these limited to defendant Garcia?
The ones I just further detailed are, but there are other items in that category from the other defendants.
Okay. All right, first of all, before I go into the big picture, I want to talk about the one photograph, all right? Mr. Kelly has been, Carey, pardon me, has been making a point that there has been an image, a particular image that he has been requesting from the commencement of the case, and he has yet to have access to it, absent taking a plane, jumping through a bunch of hoops, and going to a different county. I left the hearing yesterday pretty unequivocally in my mind, ordering the people to provide access to Ms. Oaxaca through her counsel of this particular item. Has that been complied
The
with?
people have the copy here today for counsel, yes.
And for the record, it's not an image, it's a video.
Okay.
So,
And
and my concern, Your Honor, is they're saying it's here today. Why don't I have it yet?
Okay, can we get it for him, please?
They're going to hand it to me now on the record.
All right, let's do
Yes,
that right now.
But here's the issue: is in the reports it's indicated as an image.
well, no, it's.
Can I speak, please?
Oh, sorry.
In the reports, it's indicated as an image file. The defense investigator went to look at it, and her declaration provided to the court, it is an image file. Now I'm being told it's a video. I don't know if it's the same file. I don't know what this is that I'm about to be handed. And then I'm going to go to Department 30 on 8 of 10 regarding a prelim. I would have appreciated that this be given to me when I sent the flash drive overnighted
And
last
I
week.
appreciate all of the appreciations. The reason we're here for an OSC is because the case was filed in June, and we still don't have access to the evidence. So I want to see you get that image or video or whatever it is that you've been asking for since June.
And I can clarify the image issue, Your Honor. That's just an IMG. It doesn't actually say image. It's just the way that the items on the drive are tagged.
Okay.
So there's no distinction between image and video on the image numbers. They are all IMG with a number,
Okay.
and you have to review the item to determine whether it's an image or a still image or a video, correct?
And,
Okay.
and just so the record is clear, we just handed Mr. Carey a DVR that says IMG_5662, which is what he's been asking for, and he has it in his possession right now.
All right.
I have not been handed a DVD player or a device to view it.
Okay. Okay. I understand. In regard to the representation for regarding access, people's position is anything that doesn't fall into these categories that they have defined, defense has been provided access. Is that right?
I just want to make sure the record's very accurate. So they've been provided access to some of the things in that category by way of viewing the images that we couldn't physically give them to take home with them.
Okay.
But in addition to that, the items that don't fall into that category have been provided to them to take home with them on a hard drive that the defense provided.
All right.
And I think I'd speak for Mr. Rodriguez and myself, just to separate us a little bit. And I think the court is aware. They're saying discovered and given access. This is in Fresno, where our clients don't have the means to fund the kind of operation to send me an investigative team. I believe Mr. Rodriguez is in the same position.
That's correct.
So although they're saying it's available in Fresno, we have not seen any of these items that they're discussing.
Okay. Thank you for that clarification.
And, Your Honor, if I may just respond to that, I don't recall getting, over the course of the pendency of this case, requests to make alternative arrangements from either counsel. So
Yeah, no, that's something that's just come up. But
I will
may or
disagree
may
with
not
that.
be an issue, and clearly I think that it was the purpose was to define with more clarification access.
And I'll disagree with that. It's the first time it's come up in court, but when I was asking for this one image, I believe a week or so ago, I was speaking to Ms. Callahan, and she was told that it's in Fresno, we can't get it until after the 23rd, you have to go to Fresno. Clearly, the implication was that I wanted the image, and I would like it in Los Angeles, so I would.
And I moved mountains literally to get this image to Mr. Carey today.
All right, thank you.
And it's one image.
All right, that's enough.
Disc.
We're done with the image and we're done with physical access. I want to hear about Mr. Garcia's position regarding the grouping and the access.
Your Honor, I'll begin and then turn it over to Mr. Mason to talk a little bit more about the detail. To put a fine point on it, this is not just a question of providing evidence. This is a question of timely providing evidence, which is why this court had to intervene. Just as a sort of from a historical perspective, the court will recall the reason that we came to the court in the first place was because I had made the request to the Attorney General, to the people, to get me access to and provide me all of the data, the electronic data that was in their possession. It was a relatively broad request. I was told by Ms. Callahan, she was very nice and genteel in the conversation, but very firm that the investigator, the sole investigator who had access to all of that data was not available, and her words were, I said, I've got to get it before the preliminary hearing. She said, that's not going to happen. Her words, not mine. That's why we ended up having to ask the court kindly to intervene. She indicated that she wouldn't be able to even talk to the investigator about getting that information to us until after the 24th, which, as the court knows, is well after the preliminary hearing, which is set for today. So we came to court to ask for that. This court, very specifically, sitting in Division 30, ordered the prosecution in no uncertain terms to comply with our request to have all of the data transferred to us, vis-a-vis our expert, by 5 o'clock on Monday. That simply didn't happen. That was,
Okay, thank you.
yes. Thank you, Your Honor. That simply did not happen. We did not get what was ordered by the court by 5 o'clock on Monday. We then came back to court to inform the court because the court extended that invitation. If it doesn't happen by 5 o'clock, by close of business on Monday, I invite the parties to come back and explain to the court why it didn't happen. We did do that. We were back in this courtroom yesterday morning, describing and discussing the fact that we had not been given the data that was ordered. Yesterday, the court made an unequivocal order, or I should say an unequivocal reiteration of its Friday order that we are to be granted and provided all of the data. And this is how the court styled that order. You, the prosecution, the people, are to provide every bit of electronic data in your possession. The Attorney General then returned to the court and said, returned the comment to the court and said, do you mean even protected images or contraband images, for instance, things that are considered child pornography? And the court's response was, I am directing the prosecution to give everything to the defense if in fact something is protected or it's illegal to provide. Give me something. I've heard this court once. If I've heard this court once, I've heard this court 5 or 6, half dozen times suggest and demand of the prosecution, if there are items that you believe you cannot and should not provide to the defense, file something with specificity, tell me what it is or what those items are, and we will address it. That still, as we stand here in court today, that still has not been done. What has been done is we've gotten an unverified, and I don't take issue with the prosecution's belief that this is a valid document, but it's an unverified document, not attached to a declaration or anything else that would be filed or cross-examined, for that matter, that indicates, as I counted, at least 18 items that have an N for no, not provided to the defense, for one reason or another. Doesn't matter. But they have not provided those data. Every place that there's a yes, that also hasn't been provided. And let me explain. Yesterday at about 4 o'clock, let me back up, and Mr. Mason will take this in a little bit more detail, but just to give a broad scope of what actually happened. Our investigator, Rick Green, for whom you have a declaration, went to Sacramento at great effort. He flew across the country to get there. I'm sorry, I keep saying Sacramento. Fresno, I think it is. Went to great effort to get there. Had a 5 terabyte hard drive, which is apparently massive. began the process over several days of downloading data that the prosecution directed him to download. These are our data, here you go. There are certain things you can't download, but this is the tranche of information that you can download. That's been ongoing because of physics. It just takes some time to write that data. That's been ongoing for two and a half, 3 days. Yesterday at 4 o'clock, the investigator realized that there was data in that tranche that was being downloaded that they either hadn't reviewed or had determined they didn't want us to have for one of the categories Ms. Plisner just suggested. They stopped the download, deleted everything on our expert's hard drive, and reformatted the hard drive. All of it was wiped out and wiped clean. They then restarted the data download, apparently either last night or this morning, and that's in process, and according to Ms. Plisner, it may be done in about 2 days from now. That's not really compliance. And so it's a little misleading to suggest on this very beautifully done spreadsheet that all the yes boxes means that we have all the data. We have exactly nothing. We have nothing. Well, I don't think that's quite true. I think there's a little bit of data that we do have, and I'll let Mr. Mason explain what that is.
So during the download process, which was taking many, many hours.
Yes.
There was a decision made, and then electronically that was erased.
Correct.
Okay. All right, just briefly, because I understand your expertise and appreciate it very much. I'm not so sure how that's going to bear on my decision. So I'll hear from you briefly, but I'm not so interested in the characterization of the data, okay?
Sure, thank you, Your Honor. I would like to just address two of the categories that we spoke about yesterday. And I know the court had an interest in this Gray Key issue, where there was a software program called Gray Key. The government had a contract with a third-party vendor and informed us that they would not give us any access to any information or data that they had recovered using Gray Key because of that third-party contract. Yesterday, Mr. Schultz said to the court, "Oh, we would never make that argument, Your Honor." But they still have not provided any of that information, and that includes the additional material that may be downloading now and may be ready next week. That does not include any of the devices for which that Gray Key issue was first raised. So the government has failed to comply with that portion of the court's order. The court specifically said you may not withhold anything because of a third-party Gray Key contract. Second category that I would address is the encrypted laptop that we spoke about yesterday as well, in which the attorneys for the people said to the defense, the investigator said to my expert, "We will not give you access to this unless you give us the password to the device. We can copy it, we can make a copy of all the ones and zeros, we can give it to you now, but we refuse to do that unless you give us the password." The government is still maintaining that position. None of that information has been made available, even in the materials that supposedly download has again begun. My expert, Mr. Rick Green, who we've submitted a declaration from, he's here in the hall. We can call him as a witness. I can tell you exactly what he has in his possession, which is the sum total right now as we stand here today in court of what the defense has available to it. He has a partial metadata download from 4 devices out of 61 that the government seized. That's all he has. Everything else was wiped out. And it was wiped out by the government yesterday after they kicked him out of the room, which happened immediately after we got out of court.
All right, I have what I need to make a ruling. I am going to take it under submission briefly. I'm going to call some matters in my calendar, and I'll come back to those.
Thank you, Your Honor. Thank you.
Your Honor, may I just clarify? I'm not sure that the issue regarding Gray Key that was just articulated is entirely correct. So,
I didn't see that as one of your categories. And
Right.
the court was pretty clear that the court didn't recognize that as a legitimate category.
okay.
Okay? All right, so I'm going to recess this matter for a moment. Give me a little opportunity to get some business taken care of, and I'll be